right with the Internal Revenue Officer, that is practicing before the Internal Revenue Service. Even if it's just a question and answer session, even if it's just an informal examination or informal meeting with the client, that is still the definition of practice. So you have to be very careful in terms of what you do. And let's take a look at how careful you have to be when you are practicing. Look at some of these. Such presentations, such practices include, but are not limited to, preparing documents. All of you do that, most of you. Filing documents. All of us file documents on behalf of our clients. What about correspondence? What about a phone call with the office? Now you're subject to 230. What about communicating with them in any way? What if you write a letter on behalf of your client? Now you're practicing before the Internal Revenue Service. Rendering written advice with respect to any entity. When we talk about entities, what do we mean? We mean a business. We mean a corporation. We mean a partnership, a trust, an estate. Those all fall in that definition of entity. So be careful. You may say, well, Roman, I wrote a letter on behalf of my grandmother who was deceased, and it was for her estate because there was a tax issue. You are practicing in front of the Internal Revenue Service with that letter, and you're subject to the guidelines. In a transaction, you're subject to practicing before the Internal Revenue Service. If it's a plan or an arrangement, such as a 401k plan or something of that nature, or another plan or arrangement having the potential for tax avoidance or evasion, let's take a step back. So I'm an attorney. I do a lot of merger and acquisitions across the United States, especially when I get out to the West Coast. So many of my clients tell me, well, Roman, I have an Alaskan Dynasty Trust, or I have a Diamond Trust, or I have this type of trust. And when I dig down into it, I'm saying to them, what is that? What is the arrangement that you have in the trust? Are you trying to avoid tax? Are you creating an evasion of some type? What are you doing with inside of that trust? So many of those I see are done for those purposes. Those practitioners that create those type of arrangements are subject to practice before the Internal Revenue Service and subject to Circular 230. Why is it so important that they be subject to that? Because this office can disbar the attorney. This office can de-license the certified public accountant. This office can take your certificate away. It can dismiss the enrolled agents. And that's why they do that. They want to reach out farther than just a tax return preparation. So keep that in mind. And the last bullet point on there, representing a client at a conference, as we said, at a hearing, at a meeting. Be very, very careful. And I want you to pay close attention to the 5th bullet point, rendering written advice. Because I get this a lot. I'm so grateful for how many of you watch the program and how many of you go to My Tax Courses online to listen to us every year. I know my father is part of our presentation as well. We love the feedback. We love the comments. But I'm going to give you one word of warning, and I see it over and over, that often you are trying to advise the clients, and you have to be careful with that, because you start to bend the law a little bit into the practice of law. And when you try to counsel a client on what form of company they should be, or what's the analysis of this deduction, how should this deduction be treated, you need to be careful there, because that's where you can get into some of the gray area. Are you practicing the law, or are you simply practicing your tax preparation and practicing before the Internal Revenue Service? The only reason I say that is because of all the questions I received this year. So many of them had to do with a legal analysis of the situation, which I'm glad to see those questions. At least they're reaching out. It doesn't have to be reached out to me. At least you're reaching out to someone. So be careful. So that's the definitions of representing individuals, entities, and practicing before the Internal Revenue Service under that section, subpart A, paragraph 10.2, section 4. So let's take a look now at subpart A, section 10.3. We've talked about who could practice, and this part has not been changed under the Levin case. We've given you the list, we've gone over the list, but let's take a look at some of the identifying features of each one of these people. Just look at the bottom. Look at the bottom notation we have on there. You have to be 18 years old or older, and an exam is required to be an enrolled retirement plan agent, to be an enrolled agent, to be a federal tax return preparer. Those are some of the restrictions that they put on there over the years. But let's take a look at the definition of an attorney. It's got to be an attorney who is not currently under suspension or disbarment from practice before the Internal Revenue Service. And they must file with the Internal Revenue Service a written declaration that the attorney is currently qualified as an attorney and authorized to represent the party. You're going to find in a few minutes that tax return preparers and enrolled agents don't have to do that. I do. As an attorney, I have to fill out a power of attorney form for my client, or the IRS will not talk to me, even if it is strictly about that tax return, or a certain item on their tax return, or a letter that the client received. I have to file that written declaration. And keep this in mind too. An attorney can come to you and say, well, I'm a licensed attorney, and they may be suspended from practice for a short period of time. Some bar associations across the country suspend for 30 days. Some suspend for 1 year. That's important to know if your client has had a problem, and there has been an attorney involved, or a CPA involved. They're the same way, where they may have to have the written declaration if they're not part of the return process. Interesting to note, too, if you watch the introduction to tax returns that I have, that we produced as well with this program, we go over where that designation shows up for the CPA on the tax return. Where if I helped someone fill out a tax return as an attorney, where I would sign the document to say, I did prepare it, and you can talk to me, and here is my declaration. Those are on the tax return, so it's kind of interesting to see some of that. There was a recent Missouri case where there was an attorney who was found to be practicing in front of the IRS without a written declaration that he had given to the IRS, or she had given to the IRS. So it's important to always do that. I always do it. It's the form 2848. It's the power of attorney form. It's filled out. I always indicate what state I'm licensed in at the time and what, of course, the tax matter is that we're representing. They want our bar numbers. They want things of that nature. Let's take a look at the definition of an enrolled agent. It's any individual enrolled as an agent pursuant to the Act who, again, is not under suspension or disbarment from the Internal Revenue Service. No written declaration required. Honestly, it gives all of you a huge leg up when you can contact the IRS and just say, I'm an enrolled agent, here's my number, or I'm a registered tax return preparer or federal tax return preparer, here's my number, and boom, they will talk to you about that individual return. Same thing with an enrolled retirement plan agent. No written declaration is required there either. Let's talk about the limits. And I'm on slide 12. Let's talk about the limits on a practice by you, the tax return preparer. Subpart A, section 10.3, section F. So you're limited to what? Preparing and signing tax returns and claims for refund. Signing a refund tax return or a claim if your client wants a refund. And other documents for submission to the Internal Revenue Service. You may prepare all or substantially all of a tax return, or all or substantially all of a claim for refund. The IRS prescribes the forms for you, the instructions, and other appropriate guidance. Here's another little tip that I would give all of you. It's something I did this year with many of you that sent questions in. That was to give you the publication. If you asked me about a specific deduction and said, Roman, how is this treated? What should I do here? Not only do I try to answer the question, but I try to give you the IRS publication. And they prepare to all of these. They're available on irs.gov. If you have a question about a deduction, about a credit, about something on the tax returns, about a corporation, take a look at the irs.gov website and look and see if they have a publication. That's what you're looking for, not a form. You're looking for the publication. And what that does is that describes the rules and the analysis around the form or around the deduction. One of the programs we're giving this year in the annual filing season program is home office deduction. There's a publication just for that deduction, and it is substantial. And that's what I'm talking about. So look for those. It's part of this, that the IRS gives you these forms, instructions, and other guidance to help you with this. Okay, let's still staying on subpart A, section 10.3, and we're on F. And again, we just kind of identified that they prescribe those. And take a look at the second bullet point. A federal tax return preparer may represent taxpayers before the IRS during an examination if you sign the tax return or claim. We just mentioned a few minutes ago that there is a spot on the tax return for us to sign as the tax return preparer, or if it's for a refund for the taxable year or period under the examination. The key word there is may. It's not that you might. It's not that you have a given right to do it, but they may allow you to represent the taxpayer during an examination. Now, what's the definition of an examination? Keep that in mind. It's many faceted. It could be a letter on it. In other words, your client gets a letter from them. 99% of the time, that is what is going to happen. And that's typically how every examination is commenced by the IRS, as a letter in the mail. There's a funny comment in the introductory course about phone calls from the IRS. And of course, we know an outright phone call from the IRS is not the beginning of an examination. It is fraud. But you're going to find in some of their regulations, they talk about calling you directly to initiate the examination. It's kind of a funny little dichotomy. But I want you to be very aware, there's a sentence in this section that says, unless otherwise prescribed by a regulation or a notice, the right does not permit you to represent the taxpayer regardless of the circumstances during the representation before appeals officers, before revenue officers, counsel, or similar officers or employees of the Internal Revenue Service. It also does not include the authority to provide tax advice to a client or another person except as necessary to prepare the return or the claim for refund or the document that you intend to submit to the Internal Revenue Service. That's a pretty hefty limitation. You can't help them in an appeal. Now, what is an appeal? Okay, if you have an examination and your client gets a disfavorable result and wants to challenge that result, how does that result happen? The revenue officer that did the examination of the tax return will issue, for lack of a better word, what they call an opinion. And sometimes there is a meeting with a supervisor after that opinion is rendered that the client can have with the IRS supervisor. And then if your client disagrees with the officer and his or her supervisor, then the client has the right to file a formal appeal. There's two methods of appeal that you can take. There's a short method and a longer method that you can take depending upon the severity of the tax or the penalty or the interest that is being imposed. But that is where you have a limitation. Unless prescribed by regulation, you are not allowed to represent them once they go to that appeal level. And unfortunately, I do see that question from all of you sometimes that says, well, this is how the IRS is determining this claim for deduction for my client. What can we do? Unfortunately, the answer is at that point, your hands are tied. You